I appreciate the time that he's taken to get out of the ACT Party caucus. I always used to say, get me out of that caucus now, and tried, and if I was in a caucus, the National Party caucus, I used to try and arrange appointments, particularly doctor's appointments during a caucus, but there you go. Obviously, life has changed. Todd Stephenson joins us now. Todd, it was always a great chore to be in a caucus. Is it better being in an ACT caucus?
I was going to say, I think the ACT caucuses are quite different probably from the National Party caucuses, and we actually do enjoy each other's company and debating some of the policy issues. But they have graciously let me pop out for a few minutes to speak to you.
Good on you. Listen, Todd, you've read the background to this, the new prosecution guidelines. They were published on the 1st of October by Una Jagos. And I've now read far too much of the 206 pages to be fully coherent. And the other thing that I've done is I've checked where they got their advice from, particularly on this issue, and come across an organisation called Anaya Tonuhei, which is an organisation born out of quote-unquote Maori resistance to the lack of a Maori voice, and is basically a Maori practitioners group who describe themselves as a group of passionate thought leaders leading the way. And Una Jagos pays tribute to them in these new prosecution guidelines. Again, their argument is Maori commit crime because apparently something happened in the middle of the 19th century. Your thoughts and reaction, though, first of all, to the prosecution guidelines and what they mean for equality of justice in this country.
Yeah, well, look, my reaction, Michael, is I actually think the Solicitor General has done a great disservice in her introduction to the guidelines. I think she's created a lot of confusion in those opening few pages, would be my first comment. I think you're right. I mean, this government has put out our need not race circular across the public service, which basically says we actually want public servants, including, people in the prosecution service, to actually be judging people on the merits of a particular circumstance. And look, I know, obviously, prosecution and the delivery of public services is slightly different, but the principle is the same, right? Which is we actually don't want race to factor into our government decision-making, or in this case, prosecution decision-making. So I think, unfortunately, Solicitor General, I think in her opening, 3 pages has created a bit of confusion. I think if she just stopped at page 1, Michael, it might have been a lot better. But again, diving into the document, and again, I want to make sure that your listeners don't, that we are clear that, and again, there are, the principles of the prosecution guidelines are pretty clear. Some of them are very clear, right? So, if it's a serious criminal offence, these things are still going to be prosecuted, right? So I do want people to make sure they understand. But you're right, it's where it's allowing some discretion about whether a case will be taken or not. I think where we want to avoid any perception that, a blind racial lens is put over it.
Well, I mean, they are guidelines at the end of the day. They are one of the things that was immediately pointed out to me by a defence lawyer, in actual fact, in the last couple of weeks, is one of the first questions I'll be asking the police when they prosecute a Maori client will be, did they actually consider what Una Jagos's prosecution guidelines were when it came to my client who's Maori, and whether or not they were followed?
And that's right. And that's when I think you got to dig into the detail, because, again, what we actually want prosecutors to think about is the individual circumstances of that offender, like their age, mental capacity, maybe their individual circumstances, not just say because they're a particular ethnicity, we're going to do one thing or the other. The other thing, Michael, I found is quite interesting, and I don't know if you got to the section on unbiased decisions in the guidelines. So there's also a bit of contradiction, I think, in the forward and then the actual guidelines themselves. There's a whole section on unbiased decisions where it actually says that you should consider getting like peer review and actually blinding some of your cases. So what I mean by that is you remove things like ethnicity, gender, age, etc., and have one of your colleagues look at it and see if the outcome will be the same. To me, that actually that's a very sensible thing to do. You might agree, Michael. You're actually removing some of those biases and then having a colleague look at it and say, okay, would we reach the same conclusion? That seems to me almost a bit in contradiction to some of the earlier statements, particularly in the opening of the document. So again, I don't know whether you picked that up. I appreciate it is a very large document. I haven't read it all. But
no, it's 208 pages. I haven't read it all.
No,
I've read the bit that was relevant to the conversation that we're having, and it concerned me that essentially the argument is, you've just given two good examples about age. How old were you when you committed this offence? To what was your mental capacity? In other words, if you got an IQ of under 50, or some sort of special disability, or you're off your rocker or something like that. That's fine. Yep. But this is adding, and those are long established ways in which you might approach criminal offending when you prosecute it.
Yeah.
But this seems to have deliberately added a third factor now, which is an ethnicity and historical aspect to whether or not you should prosecute. And that's new.
Yeah. Yeah, and that's completely wrong. I mean, you need to be looking at the individual cases. I mean, you could be, someone you're deciding to prosecute could be from, a well-to-do background. They might be Maori, right? But they might actually be from a privileged background. Their parents both work, and they decided to do something, out of character. Just because they're Maori, we shouldn't make an assumption they should be treated in one way or the other. We need to look at that individual circumstances of that case, and exactly like you say, age, the mental capacity, what other factors might have influenced their decision. But I think, applying this just race lens is exactly what ACT is against, and that's what we've been arguing for, and getting in place like the need not race circular.
And the other aspect of this, of course, is tikanga. Now, this is another innovation that an activist Supreme Court has decided to dig out of the grave, dress in gaudy clothes, and then make walk. This idea that Tkam Mari should in actual fact now start to involve itself in the administration of justice in this country and the way in which judicial decisions are reached. Again, that seems bizarre to me that we haven't had this, and yet here we are in 2024 starting to evolve an entirely separate branch of law, which again must contradict the English-based rule of law that has been so much a part of our constitutional makeup.
Yes, and we've heard, we've actually, a lot of people in the legal profession have raised this as a concern. We've obviously got the discussion around compulsory tikanga, legal education courses, etc. I totally agree, Michael. What it creates is a lot of uncertainty, right? Because apparently the concept of tikanga is evolving, etc., etc. So what it creates is a lot of uncertainty with our legal system and how it's actually going to operate and how decisions are going to be made, which isn't useful for the rule of law and actually certainty.
Well, I gave the example as a man that ran a trucking company, he still does, a man by the name of Green, who was found not guilty. You probably know the case, Todd, after making a dickhead of himself at a particular road accident, getting arrested, initially convicted by the district court. No question that he broke the law. That was never the issue. But in actual fact, managed to apply to the High Court, as we know, and get found not guilty, even though he'd committed the offences, on the basis that his mana would somehow be diminished. Now, I can't argue that as a Pākehā. An Indian man of Indian background can't argue that. A Chinese man, a Samoan man. But I'm a Maori, so I can argue that. And in this particular case, the High Court will strike out the conviction against me. That's a two-tier justice system.
Yeah, it is, Michael, and I think that's what we've got to guard against, right? We've got to make sure everyone is clear what rules apply to them and how they'll be interpreted and how they'll be applied. And again, that's why I think it's actually probably good that the discussion around these guidelines is being had, right? Because I think we do need to comb through the detail.